Everybody, cameras on, stay on mute. Cameras on, stay on mute. Everybody, cameras on, stay on mute. Cameras on and stay on mute. Hi, guys. What do we have tonight? That is a great question, Basement Gardener. Hi, Monica C., Les Gardner, Melissa, aka Mel, Laura in Michigan, Arbitrary Hubris, Grammy, Rita, Les Gardner again. She's a maker. Hiya. I hope you guys are all well. We had a lovely 10,000 celebration for time served just now. I hope you all had a appropriately, I don't know what the appropriate emotion is for Memorial Day weekend. Laura, thank you so much. Let's see how long Streamy takes to put that up on the board. I appreciate you starting out strong tonight. You guys are awesome, seriously. Um, I'm so happy to see you all. You're in the kitchen now. Search for Spock. Welcome, welcome. Hi, Dixie Lords. There is a read case part 3. Is there a read case part 3? You're gonna have to be more specific than read. I watch so much court, I don't actually know what one you're talking about. But if there is, we will figure it out and find it for you. Let me see. Is my audio okay, firstly? Let's say with that. Secondly, what we're gonna start with is um case that I caught today in Michigan. That's right. Hi, CRD. Hi, Hector. Thank you for commenting on all my videos today, Hector. I appreciate that. Thanks. Hi, Vaughn. Our Fulmer, Jacqueline, Delphi, Basement Gardener, Laura, Michigan, Electric Head, Gino, Streamlabs. You are sleeping on it today, buddy. Also, guys, if this is your first time here, there it is. Thank you. If this is your first time here, welcome. I'm Kitchen Court Cases. We watch court usually in my kitchen. Yeah, Toby.
Oh, yeah.
When you hear that noise, that means that somebody has made a great decision in life to join our team. If you're new here, we take attendance by clicking that like or the dislike button down in the bottom, and we watch court. I am often on the screen. Yesterday, I got a comment about that. Yeah, you're going to find me here. I am on the court. I am on the screen. So if that isn't for you, then this might not be. But we will start. I am serious. I got 2 hilarious comments yesterday that I responded to in my own snarky little way. And honestly, the reality is I appreciate arbitrary hubris. Woo! I appreciate people and commenting. I really do. But sometimes I'm like, yeah, I am part of the show, right? Anyways, and the other comment was that they wanted disclaimers in the thumbnail if there's no resolution. And I'm like, wow, you think I plan ahead a lot more than I do because I don't know what is in the case when I make a thumbnail. Are you joking? Sometimes I do, but most of the time, no, I do not. So, like, yeah, I'll tell you if I know there's no actual finale, or a resolution. But if I don't know, don't know. That is the way I see it. My friend Linny Lynn, Orlando Chiquita, love you, Donna. Bitches Against Bullshit, Mystic Lady. Oh, thank you. And I do. Crystal, I laugh. I know we're lucky if we get a title. Seriously, sometimes I'm like, you think so highly of me that I'm all that prepared, and I'm really not. Anyways, so for example, the first video we're gonna watch today, I have watched before, twice. The first time, oh no, just once. This will be the second time. But the first time I watched it is when I was recording it for the video I was posting. That's my method. It's not the best method, but that is the way that I make court videos. So, in this case, I do know that we will hear something funny. But let's get it started. If you're new here, we watch lots of Fun Court. We also have a great chat. They're the best around. They do travel around all day long to different uh, YouTube channels. And so if you have any questions, ask them. Here we go with, we're skipping to the second one. This is an indecent exposure case, and he has a pretty good argument here. Secondly, I would love to point out, and this is why I started it here, watch the tour we get right down here of this jail, all right? Watch.
24 hours, absolutely. All right, anything else then, Ms. Robinson?
No, Your Honor, thank you.
All right, thank you, Ms. Osborne, you're all set. Pretrial services. Hello?
One. It's time for court, sir. Come right up here. The magistrate's already on the screen, okay?
I hear what you're
There's
saying about
number
not
two.
having.
Make sure
Oh,
you speak right.
see, that's recording. That was earlier kitchen. I hear what you're saying about not really having a good argument for not for indecent exposure, and I generally agree. However, this guy is spitting some decent facts. I'm gonna get off of. I told you guys I renamed all of my labels the other day to what they actually are, but that doesn't mean that they make more sense to me. So, anyways, I'm just gonna pop over here while we see what happens over here.
Right through here so she can hear you. Thank you.
All right, good afternoon, sir. Are you Darcy Wildman?
Yes,
And your middle name is Jacob?
yes. By
All right,
adoption.
thank you. I can
I was
hear you
adopted.
just fine.
Keep turning me up.
All right, Ms. Robinson, if you would enter your appearance.
Erin Robinson, Assistant Public Defender for Mr. Wildman for purposes of arraignment.
All right, so Mr. Wildman, this is file 23-007070M. This is a complaint alleging on or about December 16th of 2022 at the location of 1215 East Michigan Avenue, which is Sparrow Hospital. Count 1 alleges that you did make an indecent exposure of your person in a place
They
open to the
refuse to
public.
give me
Don't
pants.
say anything.
They
Don't
refuse
say
to
anything.
give me any pants at all. So that's their fault,
In a-
not mine.
In a
Okay. This is not a Canadian jail, but this is in Michigan. Let's roll that back. We're going to roll it back because I think he has a pretty solid argument right now. He's at a hospital and he's being accused of an indecent exposure. They wouldn't give him pants. I mean, I sort of feel like he's got a point. Also, did anybody notice at the beginning when she was asking his name that he threw in, I'm adopted? Like, I don't know if that's needed information, but okay.
Count 1 alleges that you did make an indecent exposure of your person in a place
They
open to the
refuse to
public.
give me
Don't
pants.
say anything.
They
Don't
refuse
say
to
anything.
give me any pants at all. So that's their fault,
In a-
not mine.
In a place open to the public or near that vicinity in Lansing. Contrary to law, that is a misdemeanor, maximum penalty 90 days in jail and or a $500 fine.
I was
Second,
Mr. Wildman,
sir,
it's not the time right now to talk, okay? You can talk to your attorney about all of these things and you can fight it later, but she's just reading you what the police are alleging right now, okay? I know you don't agree with it, and that's okay. And we can fight the case at a later date, but now's not the time to get upset. She's just reading you what's on the piece of paper, okay? That's all that she's doing.
Okay, shut the fuck up and let her talk. Man.
okay, count 2, and Ms. Robinson is correct. You have the presumption of innocence. We're going to read you the charges, and then you'll have an attorney help you defend against the charges. Okay, so the second charge alleges that you did hinder, oppose, obstruct, or resist a Lansing police officer in the performance of law enforcement duties at or near that same location in Lansing. Contrary to law, it is a misdemeanor, maximum penalty 90 days in jail and or a $500 fine. So do you understand these charges, sir? I'm not asking you if you agree. I'm just asking you if you understand them and the maximum
I
penalty.
understand them that they're law enforcement.
Okay.
That's not.
Now, you have rights. Sir, you have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury. And at that trial, you can present or confront. Sir, let me finish. You can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one can be appointed for you at court expense. And finally, as I said, you are presumed innocent, sir. If you're found guilty, it must be beyond a reasonable doubt. So do you understand those rights, Mr. Wildman?
Trying to understand them. You gotta realize I have a head injury. I don't understand a lot. I'm disabled.
You're disabled. Okay.
Yes, severe handicap. I have brain injury.
Okay. So do you have questions about your rights then, Mr. Wildman?
I'm being released today, right?
Well, we haven't quite gotten that far. I have a few more questions answered. But let me ask you this. You, first of all, you have the right to plead guilty, to plead not guilty, or stand mute. Do you understand what that means?
Something that I did not want to do. Sparrow made me do that. They refused to help me.
Sir, we're not going to talk about it.
I'm not talking about it, but you're talking about it. That's stupid.
You're going to talk about it with your attorney.
I'm just telling you what you're telling me.
Right, and that's not when you're being arraigned. Okay. So do you have any questions about your rights?
No, I guess I don't.
No? Okay. You have the right to a lawyer. You understand that?
Yeah.
Okay. Is he applying for a court-appointed attorney, Ms. Robinson?
He is, Your Honor.
Okay. The court will enter a not guilty plea, and we have a pretrial date set. So you're going to come back to court, Mr. Wildman, on Monday, June 26th. That's at 9:00 a.m., and that is with Judge Buchanan. It can be held by Zoom, so if you've got a laptop or a tablet or a smartphone and you have access to the internet, you can appear remotely. If you don't, then you have to come to court in person. Does that make sense?
Can I finish before you cut me off? Nice. My friend bought me a Boost phone, so I have a phone now.
Okay, good. I'm going to ask you in a minute what's your phone number.
Okay. Just like that, it ends. Do you see? And I apologize. No resolution, except June 26th. Can somebody write that down? I should write that down. I should write that down. I'll write it down in a minute. What I'm going to get going is the other thing that we have on the agenda for this evening. Welcome again, folks. If you're new here, Kitchen Court Cases. We watch court in my kitchen. I'm not in a kitchen. Don't worry too much about it. It's fine. We are going to watch a TPO. I haven't watched this one either. So I am going to possibly warn you. There could be some stuff. I don't know. We're going to find out together. We will do this together. If the unknown scares you, maybe this is not the show for you. But at this point, we're going to a TPO hearing June 26th. Thank you, guys. I'd like to roll this back just a moment because this lady put on lip gloss. So lovely. So lovely. So we'll just let that play. I'll dip off screen here for 1 minute. Don't get too excited. I'm not going anywhere. But I'll pop back on when I know how many people are here, so therefore which Zoom screen size I need to use. So hit that like button or the dislike button, whichever you prefer.
Mr. Thompson, if you could please start your video. Mr. Thompson? Okay. Okay, Judge, we're ready.
All right. Okay, we have reached your case. We have been going nonstop since 9 this morning, so I appreciate y'all's patience. Just a reminder to everyone that there is no unauthorized recording allowed of these proceedings, and that applies to any participants or viewers out on the World Wide Web. Any unauthorized recording may subject one to criminal contempt consequences. Now, in this case, this is position 16 on the calendar, 23 PO 4536, LaWanda Farrow versus Christopher Thompson. I understand both of you did speak with the facilitator and tried to reach an agreement in this case, but were unable to do so. I do appreciate your meeting with them initially and trying to reach a resolution. What we're going to do now is I'm going to go ahead and have your hearing. I'm going to give you a little bit of instructions before we start. In a little bit, I'm going to swear both of you in, and then the petitioner carries the burden of proof in this case, so she gets to go first, and I will hear from her in any testimony and evidence she wishes to present, and ask her to explain to the court the basis for filing of the initial petition. Then the respondent will have a chance to ask any questions if he wishes to through me. They won't be questions back and forth to each other. And or may just choose to take the opportunity when it is his turn to tell the court what he would like the court to know about the allegations and what's going on. When one party is testifying, the other party will remain muted so that we reduce background noise on this platform so everyone can be heard and the parties will not be speaking over each other. Also, let's see, does either party have any witnesses with them that they intend to call? Okay. So based on that, so I will just go ahead and note for the record that the petition in this case was a family violence petition filed on May 8th of 2023, amended on May 11th of 2023, and the ex parte order was issued on May 10th and filed on May 15th of 2023. Service was perfected by the Sheriff's Office on May 19th of 2023, and both parties are present. So if you would both please unmute and raise your right hands. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Ms. Farrow?
Yes, I do.
And Mr. Thompson?
Yes.
All right, thank you both. You may lower your hands. And I will start with Ms. Farrow.
I do too. Thank you.
Ms. Farrow, could you please state your full name?
LaWanda Farrow.
And how do you know the respondent, Mr. Thompson?
We were in a relationship and we have a 5-month-old together.
And how long were you in a relationship?
Almost 3 years.
Around when did that relationship end?
Almost like a year ago.
Okay.
We got to do a little bit of math. Okay, your relationship ended 1 year ago, but you have a 5-month-old baby. 9, 10, 11, 12, 1. So, okay, so she was 2 months pregnant when they broke up, which accounts for the 9-month pregnancy and the 5-month-old. This kind of math, I bet kids would be able to do in school, although that was probably pretty simple math.
And have y'all ever lived together?
We did live together in Lilburn.
Okay. And how long have you been living apart?
Since think October.
And have you ever been married?
No,
And has there ever been a final legitimation order in your case regarding your child?
no.
Okay. All right. So tell me.
So, before we get into it, folks, just a little disclaimer. This hearing is happening in DeKalb County, Georgia. Georgia is a unique state in the way that they deal with parental adjudication, I guess, or legitimation is what they call it. So, whereas in a lot of states, the presumption is that once a name is on a birth certificate, then that child has those parents, regardless of their marital status at the time of birth. But Georgia is one of a few states where this is not the case. Georgia has a separate entire process for unmarried couples to legitimate their children. Um, and so, regardless if he's on the birth certificate, signed, sealed, and delivered, even if they live together at the time, if they were not married, they have to go through the legitimation process. Um, she's just the petitioner here said that he hasn't started yet. So that means that in the eyes of Georgia law, the child has one parent and it's her. Until, even though the birth certificate may say two parents on it, it really isn't the determining factor there. That is different in many, many states. And little disclaimer, I am in Canada, and that is not how it works here either. So, anyways, let's continue. But yes, she was about 2 months pregnant when they split, and yeah, you know that I don't know, Mystic Lady, that might just be drama asking for all babies to have paternity tests, but I get what you're saying.
Me, why you filed this petition for a protective order?
So like I said, me and Chris were in a relationship. We struggled in that relationship with some, I felt, control issues where Chris has followed me in the car multiple times. He's put a recording device in my car previously. While in a disagreement, he pointed two fingers at me that I felt was him pointing like a gun at me, and I asked him not to do that. He did it again. Then it goes with, calling my phone all times of night, texting my phone all the time. And like I said, we have a son together, so we have tried through mediation with his sister as well as my mom, was trying to figure out some co-parenting norms. We've been unsuccessful in that.
Well, I applaud you for trying, and I don't think that's a bad idea. However, what I would say is that unless your mom or your sister or his mom or his sister are actual mediators or co-parenting people, I'm not surprised it didn't work. That's not really getting a mediator. That's using a third party, but that's not getting a mediator. So, anyways, let's continue. So you guys are talking about perfume. First of all, just before we get going, my favorite perfume is called Lush Vanillary, and they won't sell the liquid version in Canada anymore. They sell it in the States. Apparently the chemicals are all good for you guys, but not up here. They won't allow those chemicals. Very upsetting.
So, we got here today with another incident when he followed me and I had to flag down the police for assistance to get away from him. And then he threatened to take my son another day. And then the last incident on May 4th, where he came to my home and stayed in front of my home until I called the police.
Okay, so Have you told him not to have contact with you or not to come to your house?
Yes, I have text, you do not have permission to come here. He came anyway. I have in text messages, I'm asking him to please stop texting and calling, and he continues anyway.
So tell me exactly what happened, the most recent incident.
The most recent one was on May 4th. Like I said, we have a son together and we've been trying to work on a parenting plan. He refused to finish the parenting plan with me. So I asked for advance notice for him to pick up his son. He called and texted that morning and said he was coming that morning to pick him up. And I told him, no, he couldn't come that morning. We had plans. So he continued to call and curse at me and yell at me. And he ended up coming and staying in front of my house when I told him he didn't have permission to come here. And he just parked in front of the house and said he wasn't leaving and I'll just wait for you to come out the house. And that's when I called the police to come, and the police came and spoke with both of us and they asked him eventually to leave and he left.
So about how many times did he call you?
That day, over 20. I have screenshots of at least over 20 on that particular day.
And you said he cursed and yelled. What sort of things was he saying?
Yeah. He cursed at me, fuck you, how much he hates me. I have previous texts where he's telling me what he'll do to somebody else I'm dealing with. F my relationship. It's been all types of things.
Have any of these incidents placed you in fear for your safety?
Absolutely. Yes.
Tell me more about the incident. You said that you flagged down officers.
Yes, that was on, I have the date written down. On March 23rd, we met at the school we were registering my son for. And when me and my son were actually leaving after we registered my son, Christopher continued to follow me. And I asked him to stop following me. He wouldn't stop following me. And he kept yelling that I was going to see some man. And he kept following me, and I seen an officer. So I flagged down an officer. The officer pulled over, and I told him what happened. And when Christopher noticed, he turned the corner and he was behind me. So I told the officer, you know, my child's father is following me. I just want to get away. And then he told me I can go ahead and he's going to go talk to him so that I can get away from him.
Did you see the officer talk to him?
Yes.
All right. Have you submitted any evidence or anything that you want the court to consider?
I didn't submit it, but I do have it available to show if.
Okay. And generally it has to be submitted ahead of time to the court like it had on your notice.
Okay.
But you can just tell me what those items are.
Okay. I have, like on May 15th, I have over 37 phone calls from Christopher.
So what was May 15th?
Another random day. These phone calls are all the time. I have my phone call log from February. This isn't just one particular day. This is ongoing, multiple calls and texts.
And are there any, what are the messages saying?
These are specific phone calls I have, but I also have text messages. I have text messages where I'm trying to create parenting norms, where I'm asking him times and dates to get his son, let me know in advance. And he's kind of going back and forth where I want to pick him up now, I'm coming in now, you don't control me. I have text messages where he's texting me that he's parking his car at my house. I need to figure it out, even though I told him he does not have permission to do that.
How many times has he come to your house when you asked him not to come over?
With the parking the car situation, that happened once where he parked the car and went out of town where he didn't have permission to do that. He's come over my house at least 3 times without permission, and I'm asking him, do not come over here.
When the police came out the last time, did they criminally trespass him from your residence?
No.
Okay.
I have other text. Sorry. I have other text messages where he's texting that I will eliminate anybody you're dealing with. I'm serious. He is getting mad because he texted that he wants to come over to the house with the kids, and I told him I wasn't comfortable with that. And he goes on about that. I mean, it's so many, to be honest. I don't know if I could still submit them, but I have.
Those threats about I will eliminate anybody if you're dealing with, have you gotten that more than once?
No, he didn't do it more than once. That was on a text thread.
Okay. Has he made any other threats in the past?
Other than taking my son. When he picked my daughter up, he wanted to see the baby, so I gave him time to see the baby. I wasn't home. So he said, well, I'm.
Hold on, whose daughter? Whose daughter? Oh, I'm all confused. Also, you guys are great. Make sure that you have gifting turned on in the however you do that, just because the people here are awesome. Also, this is a little bit, this is, I'm going to tell you this already. I haven't seen the end of this. This will be put in place. He could say anything and it doesn't matter. I can tell you because of how the judge is being, it will be put in place. If I'm wrong, I'll be wrong, but I'm very, very, very confident. And it's not because of the veracity of what she's saying, even though they may have been a problem with some of this, but you guys, I mean, some of the stuff we've heard before that doesn't even rise to the level of harassment. And yet some, like 37 calls in one day is a lot, but there is the caveat is that there's a need for them to be in contact. Like the guy that we were just watching over at Time Served, being all creepy on the frickin', what's it called? On the pottery lady. Well, he doesn't need to talk to the pottery lady. Well, these people have children, so they need to talk to each other. Hi Daylight. Yeah, the look on his face does speak volumes. Hi Anne's opinion. Let's continue on. I'm not saying it's right or wrong either way. I'm just saying from what I've seen of this judge and the way she talks, this is going that way. I don't think there's much anybody else could say. And once again, they were not married, but they were together. They've been broken up for about a year and they have a 5-month-old child together.
Gonna sit here until you get home, and I told him no because it was late at night, that around 9 something that evening. So he said, well, I'm just gonna sit here until you get here, and I told him no. And then when I did get home, my daughter let me know that he said that he was gonna take the baby. So I text him, don't ever threaten to take my son, and he goes on to say he's my son too. I could take him. You don't control anything. And
How old is your daughter?
she's 9.
Okay, but he's not her father, right?
Not her biological father.
Okay. All right. Anything else you want the court to know? Oh, well, let me ask you this. Are you asking the court to extend this order for 12 months and why?
I'm asking them to extend it for 12 months on myself. Not on the baby. I want him to be able to, spend time with his son, but I don't feel safe. I've told him multiple times he was making me feel uncomfortable when he follows me around, when he pops up at my home. Like I said, I'm getting multiple calls and texts. I even reached out to his sister because I know how much he values their relationship, for her support to help me in this. And she even said she didn't even know what he was doing and why he was doing that. So I want to feel safe.
Okay, since he is not, there is no order of legitimation. If I were to issue an order today, I can't award him any custody or visitation. You would still have sole legal and physical custody, and he would be ordered to not interfere with that if I issue an order.
Mhm.
All right, sir, do you have any specific questions you would like me? And this isn't a time to testify. This is a time to ask specific questions. If you would like, you can just testify and skip the question part. But do you have any specific questions you would like me to ask her about what she has testified to?
As far as the only reason that I would contact her was
So hold on. So this isn't the time to testify. You have a chance to
Okay.
testify. So
So as Judge Kim, Orlando, Chiquita, Donna, one of my great, great friends. Thank you so much. Gifting 5 KCC memberships. Thank you, thank you, thank you, Donna. Love you. As Judge Kim would say, a question is who, what, when, where, why, or how, I guess. That is, you know, that is the problem. Nobody understands. They're dying to say what they want to say, but this is not really the time. So here's the thing. He's not legitimated, so not only can he not be ordered to get visitation, he can't be ordered to pay child support until they go through that process, I believe. I don't know, actually. I feel like we talked about this before, where there was a non-pending legitimation and then but there was because you can issue child support orders as part of a TPO but the most important part of TPO is the T, which stands for temporary. They are not meant to be permanent orders. And
Yeah.
this is going to be a little bit. Enjoy.
Oh, yeah. Oh, yeah. Oh, yeah. Oh, yeah.
One of those was different. That was weird. But thank you so much, Donna. I love you. Ugh.
this has to be a
Okay.
specific question about what she testified to.
Like when she said about giving advance notice, like we
Mhm.
never, we, it was never like, okay, advance notice could have been an hour, 2 hours, whatever. We never came up with a amount of time.
Okay, so you're testifying again, but your question is back. So I think I know what so he has a question, ma'am. You can unmute. Was there any agreement as to what advance notice was?
Well, I did ask him for 2 days after the incident, but we have tried to do parenting plan and he's refused to complete a parenting plan so that he could pick his specific days that he wanted to see the baby.
Okay,
We were never able to finish the parenting plan.
all right. Sir, do you have another question?
In Georgia, legitimation allows the biological father. Sorry, I'll stop. In Georgia, legitimation allows the biological father to be recognized by law as the legal father when a child is born out of wedlock. The superior and juvenile courts have concurrent jurisdiction in legitimation cases. So, like I said, legitimation is different than custody. If you're getting a divorce, you don't need to legitimate. That's already been handled. But that is that. Oh man, now I lost the other thing. That's okay. Let's go.
For her about what she testified to?
Yeah, as far as the context of me, uh, as far as me calling her, uh, and my text messages, the gist and the overbearing effect of why I'm texting her repeatedly is because I'm asking her, I want to see my child.
So,
And,
is this, are you testifying or are you asking a question?
I guess I'll just testify then.
Okay, all right, you can go ahead. So tell the court what you would like me to know.
As far as me calling, it's a simple thing. Or just pick up the phone or reply back, hey, because I'm sitting over here.
I'm so sorry. It's not really funny. I really wish he had just done a full breakdown of how to make a phone call. Well, I pick up the phone and I go to her name and I click on it and then I wait and there's a sound in my ear. It's like a ring. I'm so sorry. Oh my God.
I'm feeling like I don't have any access to my son. And this is before a police officer actually told me about the legitimization of the child when I was there. Hey, I want to see Cambridge. I'm letting you know, please, just have him ready.
Their child's name is Cambridge? That is a university in England, I believe, isn't it? Maybe. I don't know.
So, and I'm glad I did stay there and waited on the police to come because I was in hopes of them could be like, hey, y'all come out, just bring him out, let him see him and anything like that. But the officer, he said, hey, what I have to do is, and I'm thankful for that moment because he told me, hey, so what you need to do is don't come back. I have not been to her house and I never popped up to her house. Whenever, even when I came there that time, I never knocked on the door. I never rung the doorbell. I parked up the street and I just said, hey, just bring him to the street and I could see him. That was my only thing. And
Let me ask you this. When those times, did she tell you she didn't want you to be there though?
no, she told me after the fact, she told me, you're not welcome at my house. Don't come. I haven't been back to her house.
What
When
about the time you sat outside her house?
that's the time. That is the time. That's the time when I sat like up, I was up the street. I wasn't in front of her house. I was up the street and the police officer came. I waited on them to come because I've been ignored. I've been denied every opportunity to see my son. And so I wanted to try to get some type of resolution. If the police was there, if that'll make me feel safer, make her feel safer, we can get some type of resolution. I'll be able to see my child. That didn't
What
happen.
about what she talked about when you were following her in the car after the school?
That day after school, I said, hey, what are y'all about to do? She said she had to go do something. I said, well, I'm here. I can keep him. I'll keep him. She refused. I'm like, well, where are you taking him? She refused to answer. So me as a parent, I want to know where my son is going. It had nothing to do with nobody else. I want to know who, if I can't keep my son, who are you taking him to? That's what I was feeling. Like I wanted to know exactly where he was taking my son. And no, she did not see me talking to the police officer. When I came around the corner, the police was right there. She had pulled off and he said, hey, what's going on? I told him, when he came to the car, I brought my ID out, give him to, he said, I don't need that. He said, listen, just let her go. You just let her go on where she's got to go. And that's how that ended. It was no, I cursing her out. I've never physically touched her. I've never verbally abused her or done anything out of the way. If I speak passionately, I speak passionately when I'm speaking nice to her, professing or whatever. When we were in a relationship. And I'm just feeling like in this situation, it's being unfairly characterized because of she has him physically in her custody. And only after I found out from the police officer about the legitimization process that I really don't have any rights. She has all the rights to my son. And my frustration when I'm calling her is because we need to have some I need to be able to see my child, just like, because these are real critical times. We're bonding, trying to at least. I don't have any rights. I don't come to your house.
You just said it. You summed it up, unfortunately, sir. You don't have any rights at this moment. I know it sucks. I am not advocating for George's paternity system or however the fuck they do it. Stop that. Why the fuck does it do that every time? Also, I just got rid of whatever I was. No, it's here. Anyways, I'm not advocating for it, and I'm sad for both of them. You guys know, if you know me a while, maybe you haven't, I've had a million jobs. I've run businesses. One of the businesses that I ran was a mommy group. We were called the Awesome Mommies, and we had 500 local moms, and we did activities every day of the week. And I facilitated those activities and people and groups and parents, both men and women. And I was a third party transfer for people that were in custody issues and stuff like that. Like, I'm well aware of how these things can be difficult and how sometimes you really need a third party help. But this is not the way to do it, and especially not in Georgia. Look at Judge's face. Judge is done. I gotta find my judge glasses. Fuck, where did I put my judge glasses? Okay, I'm gonna find those. Let's keep watching.
I can't knock on your door, which I don't. Any of that stuff. All I want to do, the basis of, and it has nothing to do with her being in another relationship. I could care less. All I'm concerned about is, hey, if my son is going somewhere, this is how I was feeling before I found out about the whole process I got to go through to establish my rights. If he's going somewhere, I need to know where he's going, who has him, because, plenty of times in those text messages, I told her I would never do you the way that you're doing me, because if I had custody of him, you would have access to him. I would make provisions. So those are some of the text messages you need to let you see, or read that. Read those things that I text her. I would never treat you how you're treating me as relates to our child. Another thing, like our daughter, which is not my biological daughter, but London calls me dad. And this wasn't just, hey, you got to call me dad. This is because of the way that when I met.
Are you shitting me right now? London and Cambridge? Okay. Is the other kid named Liverpool? Or Blackpool? I'm so sorry.
Lawanda, I knew there was a package deal. I immediately, London and I could be no closer because we don't even share any blood. That's my daughter. My children know her as my daughter. My family knows London as my daughter. Long before we even had Cambridge. You know, I paid tuition, anything that London needed, anything, all those things, I would do those things for my child. I don't look at London as.
Here's the thing. I have to say this. I was born in Scotland. I have a name that probably a lot of you know my actual name. I'm not going to dox myself here, but I grew up with a name where I can't explain it. It's like, it's a place in Scotland, and Scottish people think it's a ridiculous name. Here in Canada, people are like, wow, that's a beautiful name. That's so lovely. But in Scotland, they think I'm crazy. Now, it's not kitchen, MB. I know it's crazy. But and Nana doxes me all the time. But um what I think is funny is that I compare it to, like, if you live in, and this is hard because everybody's from different places, but where I live on Vancouver Island in Victoria, um, there's a city up island called Nanaimo, which is sort of a cool name. It's like Nanaimo, that'd be cool. But here, everybody would be like, Nanaimo, that's ridiculous. Like, that's not a name. Um, the night Nana doxed me was funny. She does it all the time. And I've talked to her about it, and literally we rehearsed what we were gonna say. Um, yeah, anyways, let's continue. I shouldn't have interrupted with the story. I can't really tell properly because I'm not willing to dox myself.
Being my stepchild or anything like that. That's my child also. That's how I felt about the situation. You know, London lost her dad when she was 3. You know,
Okay, so we're getting off, we're getting off of
No,
whether there's,
I'm-
so the
I'm not-
calling, repeated calling and
It
the
was-
following. You're saying you were doing that because you wanted to see her child.
that's the only reason I wasn't calling her because she's in a relationship. I don't care about
So
that.
did you text her something about eliminating somebody she was in a relationship with?
When in the context of what that was when I meant, and that's why like a lot of times texting stuff gets lost in translation with texting. When I say eliminate, I mean like because if this is stopping you from allowing me to see my child, yeah, we need to eliminate that whole process because it's not right. I would never do you like if I was in a relationship, I would never do that to her. If I had custody of my kid, it would be understood.
Eliminate is just a bad word. That's not a good thing to say, my dude. I'm trying to get into the chat here. Eliminate is just a bad word. I am in the chat. Wow. Hey, the delay is really slow, really short today.
All right.
A lot of me calling is I'm frustrated. There's a lot of kids, it's a lot of people out here, men who would love to see their kids, or who don't even want to see their kids. I'm not that person. I genuinely love my son. I love London. You know, I have no interest in being in a relationship with LaWanda. That is dead. That's over. I just want to be treated fairly in this whole process with being able to see my child.
Okay, so, but you understand now that you don't have any legal rights at this time.
I do understand that now.
And so, but the problem is, well, is there anything else you wish the court to know about what's going on?
Yes, like even after like the date of this protective order was filed, that on the 15th, she was like, she contacted me even after she filed this. Even if I hadn't been served yet, she called, she texted about me sending the child support, sending money.
Is there any child support order in place?
No, and I was paying what I could, you know, when she would ask. So me not knowing, she asked me on the 15th, and this was filed prior to that, but you still asking me for money, you know, and even after we went to a competition, London is a cheerleader. We left the competition, and we went and had dinner. Me, London, LaWanda, and Cambridge.
What day was that?
You have to ask her the date of that day of that competition, but I'm sure it was me, London, LaWanda, and Cambridge.
What day was that?
You have to ask her the date of that day of that competition, but I'm sure it was either after this. I think it was after that, or I think it was after she filed this petition. We all were together and we had dinner. I'm no threat to anyone, not even myself.
So, well, there's different kinds of threats. People can be harassing, intimidating, and you know, if you don't have legal rights, you can't just keep doing something until she changes her mind. There you have to go through the legal process. You can't force someone, and that's what these allegations are.
Right.
And I hear what you're saying, but it also doesn't legally justify them. So hold on one second. So ma'am, did y'all go to dinner after you filed the ex parte order?
No, ma'am. No, ma'am. That was in April. That was my daughter's cheerleading competition, and it was me, my daughter, Cambridge, my cousin, and Christopher. Actually, me, my cousin, and Cambridge rode down together, and I have recordings of those calls. I got cursed out and harassed the whole ride when we were down there. I have text messages with him asking me the hotel, and I told him I was not comfortable giving him the hotel we were staying in, but I did give him the location and the schedule for the competition if he was coming there to support London. So he did have that. We did go out after that, and because we were with somebody else, it was not me, him. And
when you say he cursed you, what was the gist of those messages?
He was yelling at me because he wanted to know specifically where we were on the road. And I told him I was not comfortable telling him my specific whereabouts because of past behavior and my timing of where I was at. But
what past behavior were you concerned about?
Chris following us around and popping up on me.
Okay.
And Ma'am, do you mind if I ask you a question about the TPO? Is that okay?
You may. I haven't made my decision yet, so you may ask.
Okay. Speaking with the advocate earlier, I know we were discussing what did I want to do future wise, and I know his concern was with I guess the narrative. Chris is a veteran, and I do not want to do anything to harm him. I just want to feel safe myself. Would this affect him in any way as far as his veteran, with his benefits and his?
I don't know anything about that. He would have to talk to an attorney. It's not a criminal case, so I can't speak to that. He would be, if I issue one today, it would prohibit him from possessing a firearm, federally. But other than that, I can't speak to what collateral effect it could have.
Okay, thank you.
All right. Are you still asking the court to extend this order for 12 months?
For myself, yes.
Okay, so I can't.
Before she continues on, because somehow this goes on for a while, but here's some great advice for you. Firstly, if you are going to have a kid and you already know the name that you love for that kid, don't tell anybody that name. Just keep it to yourself in this little box and then have your kid and name your kid that. And then everyone is obligated to be kind. Okay. If, however, you say beforehand, you go and tell people your name because you want advice, you're going to be disappointed. People will ruin almost all names for you. The real way to test your child's name to see if it is appropriate and or embarrassing is this. You go to a busy place, you go to a mall, you go to a park, you go to a downtown street. You stand there and you need to scream the child's name as loud as you can, many times. So loud, louder than you've ever screamed things before. And if you feel stupid while you're doing that, you're going to not want to use that name because that is the real thing. But if you like the name and you want it, just don't tell anybody. That's the way to do it. I originally had my daughter a name that honestly could work with this family. Not quite, almost. You might feel stupid screaming any name in Walmart, but believe me, when your kid's missing, you're screaming the name. So, in my province of British Columbia, they actually have the vital statistics website where they tell you the top or all the names in the province and how many kids are named that every year. And so I specifically wanted a name that was like in the middle of the list for my daughter. I didn't want like a very popular name, but I also didn't want like a really unique name for various reasons. And so, anyways, um, I remember I was partway through that story. Maybe I finished it. Basically, oh, okay, I can tell you this part. So when we were I was like 19 when I got pregnant, 20, and we would go out to dinner a lot, me and my ex-husband, and we carried around this piece of paper and we would go to restaurants and you know how they have like crayons and stuff at restaurants. We wrote our baby name list with crayons and different pens and stuff that we had found and we carried it around with us and you know finally we came to a name and we were really excited about it. And then I went into labor and we had the baby and the baby was in my arms, beautiful baby girl. And my husband, he wasn't my husband at the time, but he ended up being my husband for a while. He came in or he came like sort of leaned in and he said, "Oh, is this Venice?" Because that was the name that we had picked. And viscerally, I don't know why, but viscerally had a reaction. I said, "No, no, that's not her name." And he was like, "What? Like, this is the first time you've said that, like that, it was out of the blue. We had picked this name already, Venice. because I was like, I want Paris Hilton, like Paris, but Paris Hilton, all those things, like you can't have Paris. So I came to Venice, which I still think is a beautiful name, and anybody's allowed to use it now. I didn't use it with my baby. Um, and her name is much more common in reality than Venice, but she is who she is. But it was very funny because at the very last minute I really like freaked out. Oh, Jody, everyone pretty much knows my real name too. I was on before as my real name for the longest time, but when I teach people about internet safety. Okay, let's hear how this ends, guys. Let's see how we go.
Can I say something, Judge?
You may.
All right, the time what I'm talking about, I'm not talking about Jacksonville when we went down to Jacksonville for London. I'm talking about what she did the tumble off. After we left the tumble off, we went to have dinner. It was myself, LaWanda, Cambridge, and London at that time. And that's the truth. I wasn't talking, and no, there was no one else there but us four.
Okay.
That's it. So that's what I was talking. I'm not talking about.
Okay. Hold on.
Jacksonville.
I understand. So, ma'am, do you recall the incident he's talking about?
Yes,
For
and
the time?
that was before this was filed.
Okay. All right.
But that was after we left Jacksonville. And
Okay, I understand that. That was another time.
That was another time after we left Jacksonville.
Okay.
And I'm saying like, so I'm feeling like after we came back, and I wasn't expecting anything after that. I know London wanted to go eat at this place that we used to always go to when we were a unit. So we went to that place. London had did very well, so we went and had dinner. There was nothing. After that, hey, this is when things got like, hey, I want to be able to see him.
I understand. And so, hold on. So so it's gotten to a point though where she filed because she felt like her testimony, it wasn't going to stop. And leaving her in fear for her safety. You've testified that now you understand that you can't force her hand, so to speak, as it comes to the child, and you have to go through the legal process. But until that happens, I do have concerns that there will be ongoing issues.
Not at all.
Well, the past, I find that there have been acts that have occurred, and until you've gone through the legitimation process, if she says, don't come to my house, you can't come to her house.
I haven't been to her house, Judge, since this.
Right?
Yeah.
But it kind of took this to get your attention.
No. Not even protective order. Before the protective order, when I spoke to the police officer, I have not been to her house. That's before.
The time at her house or the time that you followed her?
No. Before. After the police officer, after we I wanted to see where she was taking my son. And I spoke with that police officer. And then we were in front of her house. I was waiting on the police. I have not been to her house since that time. I have not, and this has been a while ago. I have not been to her house.
So let me ask you this, Madam Petitioner, if I were to issue one today, how would you anticipate, and you're asking me to not include the minor child at all?
Yes, ma'am. I don't want to stop him from having a relationship.
How would you all go to extracurricular activities, or how would he contact someone about seeing the child? How would that happen?
That's what I was asking the advocate about, being able to use a third party. My parents are here quite often. I have a cousin that lives here that we could use. He has adult children that we could use. I would be open to using a third party if that was acceptable.
So I can't award custody if there is no final legitimation order or visitation. I can't really make that part of my order because legally I do not have the authority to do that.
Mm-hmm.
All right. Okay. I am going to issue an order I have concerns that this will continue at least for now. Now, but I won't, so it's going to say you can't come within 100 yards of the petitioner. Okay. I will leave out the child part. I won't,
Judge.
yes. I'm not going to argue with you on this.
No,
I
no.
understand you're telling me that you're not going to do it, but there's been an admitted history of doing it. So legally, I just have to find by a preponderance that there's a reasonable likelihood of it continuing until it's resolved in the court system. Do you see what I'm saying? I mean, that's,
Yeah, I just wanted to say,
yes.
and my feeling is if it may be a situation where we may end up in the same spot unknowingly.
And that's what, so you might have to just walk away. But here's my question, and that's why I was asking the petitioner. If you go to an extracurricular event and he can't come into that 100 yards of you, then he can't be at that event if it's a child's event.
I'm asking.
Are you asking for, so you want him a stay away?
I just, Judge, if I may, and I'm sorry.
No, hold on. Don't interrupt me yet. Let me ask her.
Okay.
I'm not trying, again, ma'am, I'm not
I know
trying.
you don't want him to, I know you don't want to interfere with his seeing the children, but I also.
Sometimes I really do wish lawyers were here for this. This was already decided. She just made an argument, or she just made the decision and then shut the guy down and said, I'm not arguing with you about this, sir. And then she says, are you sure you want this? Ma'am, we already know domestic violence victims go back and forth, unfortunately, due to the trauma and abuse. And so, as the judge, I really wish she would have just been sturdier on this. I agree, MB. This could have all been worked out, including custody in a 3-hour mediation with a real mediator. However, they tried to use their sister or a friend or a mom, and that's just not far enough apart. You need literally somebody that both of y'all are paying, that you're like, okay, let's just do this for one time, get this fucking done, and then move along. Aw, Susie, I'm so sorry to hear that. Oh, dear friend. I hope you're okay. I think the judge has already made sure legally, Craig. Honestly, like, in my opinion, the judge has already, by the way, the judge and I look so similar with these glasses on. I've been just mimicking her the whole time. But I believe that the judge has already made her decision. If she hadn't, why would she reprimand him and be like, I've already made my decision, I'm not arguing with you? So, I don't know. Anyways, also, guys, I am working on a book club for us where I will be reading the books. So if you don't want to read them yourself, I will be reading them aloud for us over a period of time. So anyways, I just wanted to say that because I see in the chat we like talking. They won't be the Harry Potter books. Sorry, guys, I don't have that kind of money to output for Harry Potter. Or well, I probably would have the time, but anyways, let's continue.
Well, here's the thing. So here's where it is. I'm going to leave it. So there are no legal rights to the child at this time. So I'm going to say the no contact, but I'll leave it just with the petitioner. And if she chooses through a third party for you to have contact with that child, that's her decision. Okay. But you can't contact her.
Okay, this is what I'm saying. What I would like to see happen, and you're totally in charge. I have no desire to. I've never had any desire to harm Lawanda in any way, and I think that this protection order, is, and then it I would like for her to drop it and we order us to go to some type of more mediation.
That's not appropriate in cases of family violence. And
There's
I know
no-
you're saying you've never laid a hand
no
on her,
violence, no
but
violence.
stop, sir. Let me tell you what the law says. Following someone when they tell you to stop and they don't want you to follow them, calling them repeatedly and showing up at their house waiting for them to come out are violations of the law. Okay, that is also types of family violence, which is why I'm issuing this order. I'm not going to order people into mediation and counseling. If you go through the legitimation process and get a final order, that may be grounds for modification of this order. Okay, but until that happens, right now, I have concerns that this is going to continue in the future. So I'm going to issue this order. It will be in effect from today and will expire on May 29th of 2024, unless anybody comes to the court and asks for a modification or dismissal before then. The respondent is ordered to not come within 100 yards of the petitioner. I'll leave out the minor children, so there is an opportunity if she wishes to have you set up, allow you to see the child, so that wouldn't be a violation, which normally you wouldn't do in a case where there's not been a legitimated parent. The respondent's not going to have any contact directly, indirectly with the petitioner, okay? And she already has sole legal and physical custody of the minor child. But if you get your legitimation order and go through the courts for that, I will allow that may be grounds for modification of this order, okay? And that order will address custody, child support, visitation, all of that stuff in the long term. This is just temporary because things seem to have escalated and need to be intervened, and there needs to be a cooling off period. I will order the Family Violence Intervention Program. That compliance date will be June 23rd at 9 a.m. And it's virtual, and we'll place you in a breakout room to speak with someone to get that information so you can get started on that class. And while this order is in effect, you cannot possess a firearm.
So, the question was just posed there, how can he legitimate if, without cooperation though? Insert funny name. Well, because it's a legal process. So he can try and serve her. If he can't serve her officially through the regular channels, he can petition the court to serve her in other ways, meritoriously, I think it's called, or notoriously, one or the other. Anyways, I agree though, this is the part of the real loser here is the child. Absolutely the child. It is horrible and sad, and it breaks my heart every time. What I hope is that him taking the Family Violence Intervention Program, or FVIP or FBIP, they are called in different jurisdictions. So FVIP is for family violence, FBIP, family batterer, I think. Anyways, the intervention programs that are put on by the state are good for them to go through. And I do hope that this rectifies for them eventually. We're not done yet. I'm not breaking this early, guys. Also, there are lots of you here. If you're new here, please hit that like button. Or the dislike button. That's fine. Either is fine. But also subscribe if you're not already. You guys should be all in the 2K club. That's what we see here. Hit that likey, and what we've got going for us next is, I'll let this play out while I pull the other one. Okay.
Okay. And I understand that that's not what you wanted, but I have concerns about the ongoing issues surrounding the child at this time and how it is affecting the petitioner. So ma'am, you should get a copy of the order once it's been filed. And sir, if you do not get a copy of the order, you can contact the clerk's office to get one. And the clerk's office also has information at the Family Center about legitimation process. And so at this moment, I'm going to place you in a breakout room to speak with someone about the getting that information to the compliance officer. Do
Thank
you
you.
have a question, sir?
He said, peace out. No, he didn't. But that was the end of that video. So, guys, that's just exactly one of those cases. We did get an ending to that, but we didn't necessarily get, well, I didn't know what it was going to be about. That's what I was trying to say. Anyways, as we continue, what I'm going to pull up next is a first appearance docket. I just need to check which one we're gonna go with. Also, guys, oh, okay. Sometimes literally this has just happened where I'm like scrolling through videos that I downloaded that I didn't even look at yet, and this guy's outfit has made me, we're going to watch this now.
Okay. It'll make a difference of $1 million over the course of your lifetime if you get a GED or a diploma. All right, I don't have any other questions then, Ms. Robinson, if you would address.
I do. You're starting out the video spitting facts like that, ma'am. We're gonna have to reverse this up and see what you're talking about. Literally, this is the whole video. Didn't stop any part. Also, med check. Thank you, Jody. I literally just shook the meds, and I know somebody else said it up there too. Med check, folks. What med check means is if you take medication, go make sure you've taken that medication. If you don't take medication, come down into the chat and let us know what that's like, because we all take lots of meds. Seriously, I was on my way to a different video, and this guy's shirt made me watch this. Also, I have absolutely no clue. Literally no clue.
Okay. It'll make a difference of $1 million over the course of your lifetime if you get a GED or a diploma. All right, I don't have any other questions then, Ms. Robinson, if you would address bond.
Yes, Your Honor. Mr. Smith is from Lansing originally. He does have family here in the area. He's not on probation or parole. These are nonviolent offenses. We would request a personal recognizance bond.
The court will do just that. You have the same address that you had in 2018, and this bench warrant's been in place probably since January of 2019. So it appears that you either haven't had any contact with law enforcement, or they considered it a minor offense. I'm going to choose the former rather than the latter. You're still here, and I don't see any reason why you wouldn't continue to appear, because this thing is going to haunt you if you don't. If you don't come to court, another bench warrant's going to issue, and it's just going to balloon like that. So it is a $300 personal recognizance bond, sir. Don't miss your court date, and don't violate any state or local laws. Does that make sense?
Yes, Your Honor.
Okay, anything else for the record then, Ms. Robinson?
Oh, Your Honor, thank you.
All right, then that concludes your arraignment, sir. You are all set.
I appreciate you, Your Honor.
Sure thing, take care.
Will he skateboard out? Will he skateboard out?
All right, we're gonna go to the mobile cart.
Were those tearaway
That's
pants?
correct, ma'am. Do you have a preference? What we do first?
I do not. Do you, Ms. Robinson? No. Okay,
Thank you.
you're welcome.
Craig, the question that he said, is legitimation needed because dad didn't sign the birth certificate? No, it is needed because they were not married. Even if he was on the birth certificate, because they're not married, it's not. When they're together, that's totally fine, and he has the rights of a parent. But as soon as they break up, damn, is this video gonna suck for the rest of it? Let's just see this. Oh, the judge is coming back. Let's stick with it. What is she drinking here? Is that green? Never mind, let's skip.
Okay,
Oh.
Officer Lawrence, who am I seeing here?
This is Miss Osborne, ma'am.
Great. How are you today, Ms. Osborne?
So, even funnier, see if I paid attention better. I made a video with this girl in it already that I posted today. We watched the second half of it earlier. She was in the first half. You guys remember the plexiglass? Um, damn, maybe I'll have to pull the. Damn it. Damn my ADD.
I've had better days.
Oh, I can't hear.
I've had better days.
Okay, yeah, well, yeah, I can understand that. Is your full name Mary Louise Osborne?
Yes, ma'am.
Okay. Have you had a chance to speak with your attorney today, Ms. Osborne?
I've spoken with their magistrate, yes.
Okay, good. All right, so then, Ms. Robinson, if you would enter your appearance.
Erin Robinson, Assistant Public Defender for Ms. Osborne for purposes of arraignment.
All right, thank you. Ms. Osborne, this is file 23-01671SM. This is a complaint alleging on or about May 30th of 2023 at 1114 South Washington Avenue, apartment 5 in the city of Lansing, Ingham County, Michigan. Count 1 alleges that you did make an assault or an assault and battery upon Ranjit Gorpad, a resident or former resident of your household, or an individual with whom you had a dating relationship. That is contrary to law. It is a misdemeanor, and it carries a maximum penalty of up to 93 days and or a $500 fine. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. So do you understand the charge and the maximum penalty, Ms. Osborne?
Yes, ma'am, I certainly do.
Okay, you have rights, and I'm going to go over those with you because they're really important. So you have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury. And at that trial, you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, and if you are found guilty, it must be beyond a reasonable doubt. Do you understand those rights, Ms. Osborne?
Yes, ma'am, I certainly do.
I can't understand. Can you just turn your face toward?
I do, yes. Yes.
You
I
do?
understand.
Okay, good. All right, then is she applying for an attorney today, Ms. Robinson?
She is, Your Honor.
Okay, thank you. So with that, we're going to enter a not guilty plea for you, and we have a pretrial date set. Ms. Osborne, you're going to return to court for a pretrial on Tuesday, June 27th. That is at 2:00 p.m., and that is with Judge Stacia Buchanan. That can be handled by Zoom. So if you have access to a smartphone or a tablet or a desktop or whatever, you can appear remotely. If you don't have that access, you would have to appear in person on the 6th floor. Do you understand that?
Yes, I do.
Okay. And you've got the notice to appear and the Zoom instructions, correct?
Yes, ma'am.
Just like that, it's over. You see? That's what these people do. They are. So, actually, it wasn't over because I played other hearing afterwards, but that's not what we're doing. I'm getting distracted again. We're going to watch the. Oh, I already. Sorry, I am already distracted. I need another ginger ale. Okay, do not be distracted by their clothes. Decide. Yes, let's see.
There, your name?
Mm.
Sir.
Terry Drummer.
Thank you. Bill State of Michigan versus Terry Drummer, case number 19FB1503. See here.
I'll be right back. I'll have Larry Beaver step in for me while I'm gone.
All right, well, I saw you August of 2020. You were at the jail at that point in time as well. You were arraigned on a violation of probation. Matter was set for violation of probation hearing for September the 14th of that year. You failed to appear and a bench warrant issued for your arrest. Do you understand that?
Yes.
So we'll have to schedule a new violation date. Ms. Pearney, would you like to address bond?
Yes, good morning. Assistant Public Defender Lauren Kearney on behalf of Mr. Drummer. We are asking for a personal bond in this case. Mr. Drummer has a 9-year-old daughter who he cares for. Additionally, he is eager to get out of custody and return to his apartment. His lease is up soon, and he is worried that if he does not return and either renew his lease or move his things out, they will just throw all of his belongings out. He works 2 jobs. He works a construction job and at a company called Real Truck where they build truck covers. So we're asking for this case to kind of be reset. Mr. Drummer and I talked about his probation and he knows he needs to complete some things. During that time, it was kind of the middle of COVID, or I guess the beginning of COVID. And he just had a lot going on, but he is willing and able to complete what he needs to now.
The original violation was in August of 19. Prior to that, the defendant had failed to appear for a review hearing, and then there was a violation entered. So that was all prior to COVID. He was already demonstrating non-compliance with the court orders. Appeared in custody, was given clear indications as to when he needed to be back into court, failed to appear again, and now was absconded for pushing up onto 3 years. Court's been given no information that indicates any reason for that other than general. Maybe it was busy, maybe it was COVID, things like that. But we don't have anything that mitigates against changing the bond that the judge originally ordered when the bench warrant was issued. Matter will be set for a violation hearing on June the 12th at 9 a.m. Via Zoom. As indicated, the court has concerns with regard to appearance at that court date. So, of course, not changing the judge's original order of bond, which is the amount of $20,000 posted either in cash or corporate surety, meaning through a bail bondsman, Mr. Drummer. So if you want to reach out to a bail bondsman, the jail can help you make those contacts to get that those calls made. Okay.
I couldn't barely hear you. You said bond at what?
Same as it was originally, 20,000 cash or bail bondsman. So you can get a hold of a bail bondsman and see if they're willing to help you post that. Okay.
Okay, and you said my next day is June what?
June 12th.
For probation violation?
Correct.
Okay.
All right. Thank you, sir. Have a good day.
This is Larry Beaver for anybody who's new here. Larry Beaver. He also comes in many forms. Referee Beaver. Pizza Slut Larry. Vampire Larry. What other way? Just regular old Beaver. Oh no, this one's the Scarf Beaver. All of these are for different reasons. And we use Larry as a beaver buffer dam when needed. And also Larry steps in for me when I need to go to the bathroom or something like that. or get rice to eat.
Mr. Hamilton, today, please, they're waiting for you.
Good morning. Your name, please?
Charles Hamilton.
Be with you in just a moment, okay?
Okay.
Bill State of Michigan versus Charles Hamilton, 2FB1263. That's a review hearing, May 2nd, excuse me, of 2023, but a bench warrant issued prior to that in February of 2023. Let's see what we have there. All right, allegation that you left transitional housing February 25th, 2023, and as of February 27th had not returned in violation of the court's orders to be in transitional housing. So bench warrant issued for your arrest for that reason. Do you understand that?
Yeah.
Ms. Perry,
If I can say something, Your Honor,
your attorney's gonna speak for you at this moment, and she'll tell you whether or not she wants you to follow up on anything. Okay.
Okay.
All right. Thank you, Ms. Perry.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hamilton. We are asking for a personal bond in this case. Mr. Hamilton has completed essentially the bulk of what he's needed to do on probation. He completed treatment at Don Farms. He currently has a sponsor. He attends 3 12-step meetings a week. He has written letters of apologies to the officers. His aunt recently had a stroke and he has been staying with her to help care for her. He is fully employed and is working on getting his own apartment. He has been in jail since Friday afternoon and was arrested because he was staying with a friend and wasn't responding to anyone. So a missing persons report was actually entered, but he was not missing, just hadn't texted his family back. So we don't see any charges coming from that. We'd ask for a hearing date, but as I said, Mr. Hamilton has been working hard to complete everything on his probation, and he has been caring for his aunt who's been ill and has had a stroke. So again, we're asking for a personal bond.
Thank you.
This is Michigan, I believe.
Well, certainly one thing to have a not reporting to probation or other, sort of less serious issues with regard to probation, but leaving a treatment facility as ordered by the courts is something the court does have to take into consideration as a serious matter, particularly had there been any mitigating factors that the court could have taken into consideration with regard to leaving the treatment. Those should have been brought to the court's attention, and there should have been a plan between the defendant and the court to make other arrangements if there's a necessity to leave for family reasons and things of that nature. That wasn't done. And no contact has been made to the court subsequent to that either. So now we're talking a few months on. And apparently no communication with family members as well. So that does raise additional concerns with regard to what's going on here with regard to the defendant. So the judge, when issuing the bench warrant, issued a $20,000 cash surety warrant for the reasons stated here on the record with regard to the seriousness of leaving a treatment facility in the midst of a probation order. The court's not going to change the bond. There's no indication that there's any reason to lower that. So bond set amount of $20,000 to be posted either in cash or corporate surety, meaning through a bail bondsman. Next court date will be the violation here on June the 12th at 9 a.m. via Zoom. All right, Mr. Hamilton, you're all set. If you want to reach out to a bail bondsman, the jail staff can assist you with that. Okay.
All right, thank you.
Thank you.
Here, you can go to court. We're allowed to speak for a second, okay? Yep. Okay, well, you're on 14B court right here.
14B court right here. She just said it.
Good morning. Your name, please?
Timothy Scott.
Scott?
Yes.
One moment. All right. Field State of Michigan versus Timothy Scott, 21 FB 1506, 20 FB 1525.
Oh, we have one of our resident Michigan experts, I would say. One of my good friends. That is the way I see it. Ladies and gentlemen, if you're not already subscribed to that channel, that is a must do, although I have to trust that most of you are already subscribed. But if you're not, that is the way I see it. Amazing channel, lots of Michigan court content, lots of court content. The guy is a hard worker. I will say that. And in this chat, we call him Titwissy. Titwissy, Titwissy, Titwissy. And some people shorten it and get rid of the tit. And I am never an advocate to get rid of the tit. I like tits. Anyways, let's continue on. Magistrate Mark Nelson. That is the way I see it. It says same county as Judge Washington and Simpson.
All right, first matter has a violation of probation. The allegation is that it's violation of no assault over threatening behavior condition of probation for reference Canton Police Report 2200260079 and failed to enroll in accountable choices program as ordered. You understand that?
Yes, but I don't understand how I got assaultive behavior if I didn't assault nobody or anything.
There's a police report that indicates there was some sort of assault. There'll be a hearing on that. So your attorney will get a copy of the police report. They can sort all that out. Unfortunately, I don't have the police report or anything. I just have a reference to that number at this point in time, but there'll be a hearing on it. Okay. All right. Your other case.
Well, then I have some good news for you, Alex, because Cook Week 2.0 will be happening starting on Thursday of this week.
There's no bench warrant.
No warrant for this one?
That's what I'm trying to sort out.
And I will be baking bread and goodies and all during day and evening. Cook Week. We already did it once when I was in another kitchen. We are doing another Cook Week, and it's starting this Thursday. Because Nana's going out of town for a week.
Looks like we just have the one violation on the first one, so we'll just deal with that right now.
So I only got one violation, correct?
That's what I can see here at this point. Yeah, I mean, there's 2 allegations in that violation, but yeah, just the one case has a violation on it for this court. I don't know if you have other things going on with other courts right now, but your public defender is going to address bond for you.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Scott. We are asking for a personal bond on this case. Mr. Scott, I did look in Canton District Court, in the 31st District Court, did not see any cases filed in reference to this police report or any other police reports, any other assaultive cases. I believe the only thing he had there was a speeding ticket from a few years ago. So there was no cases that came out of this report. Mr. Scott is going to be in the Washington County Jail until at least June 8th. He has a pending CCW case. He is employed. He works at Chipotle. in Ann Arbor. And we're just asking for a personal bond on this one. So if his other cases are resolved, he can be released at that time.
How long has he been in jail now?
I think 2 days. Yep, 2 days since Saturday.
And how do you have getting arrested Saturday?
I didn't ask Mr. Scott, how
Or
were
was
you?
that CC? Is the June 8th date is probable cause conference for the?
It says in Excel it says pre-trial. I assume that means probable cause conference. It's not in the circuit court yet.
Mr. Scott, did you see a magistrate over the weekend?
For my CC, for the other case, yes.
Okay.
Yes, sir.
All right. And you're being held on bond for that case right now?
I got she said yes, a $5,000 bond.
Okay.
It's a $50,000 bond.
A $50,000 bond.
Okay. All righty. Okay, we'll set this for a violation of probation hearing June 12th. Court does unfortunately have to take note that there's a new potential violation of probation also with regard to this latest arraignment. So that does fall into consideration with regard to the bond determination.
Hold on, wait, what happened?
Well, you got charged with a new crime, so that's another violation of this probation potentially. So I just have to take into consideration. All right, the original bond was set in the amount of $5,000. We posted in cash or corporate surety for this case. We'll set a June 12th violation date for that hearing. Court's going to maintain that bond amount based upon the information provided with regard to assurance, public safety, and appearance at future court dates.
Hello, how much?
Hold on. Thank you so much, Lisa B. I don't know that because they're awarded one, they don't necessarily have to be here. So I did not see Keeper tonight. Just as an FYI. Oh, for fudge sakes. Anyways, thank you, Lisa. And guys, make sure you clocked in for your shift tonight in the kitchen down below using that like or the dislike button. That's how we take attendance. Like I was saying, Cook Week coming up, guys. We are, oh, Lisa, that is very sad about your stepbrother. I'm very sorry for everybody that's had some losses today. I know Susie was having one. Lisa, I know Amy's having a bit of a hard time. Everybody, my thoughts and prayers are with you. Well, I'm not gonna lie, not my prayers. I don't really pray, but my thoughts are there. So I love you all. Let's continue on with this. Keeper was in today. Was she in here? I feel bad then. Uh-oh, Alex had to lose. No one showed up to the dog club tonight. Alex is in a midnight dog club, guys. A little bit sus, but that's okay. Your husband walked into the porno sound and the side eye was hilarious. Now that's great. We've gotten a couple reports of that tonight. I will actually make it porn sounds eventually if we want. I love you guys so much. Seriously. I'm gonna be making my famous chocolate chip cookies coming up this week, but I know Daylight wants me to make something. So maybe I'll be making that coming up this week, Daylight. Let's make that happen.
How much is the bond? Could you slow down a bit?
Sure. Yeah, no problem. It's a $5,000 cash or surety bond. So you can post it either in cash or with a bail bondsman. So if your bond gets reduced at your next hearing on your other case, or you're able to post that bond, then this bond's lower than that one. You can get this one posted, or or wait till your next hearing and see if it's reduced then. Okay.
So I got $5,000 for this one, and then $50,000 for the other one.
That's what Ms. Pierney just indicated. Yeah, $50,000 for what you got arraigned over the weekend. So if you,
sorry.
Go ahead, Ms. Pierney.
And then you have the probation violation in the circuit court for today, and that your bond's denied on that one. So that one will have to be taken care of as well before you're released.
All right, and before any of that, so basically it's $55,000. Basically.
Combining the two cases together, that's correct. Yeah.
But in reality, it's no hold or no bail, dude. Did you not hear? You got bail denied for your probation charge. So 55, 60, 80,000, you can't get out. So I do share recipes, of course. I also like to try people's recipes. Please keep in mind, I am in Canada, so sometimes it's a little harder for me to get certain things, but I'm getting a PO box and I want to try all the stuff you guys want to send me. Seriously. I'm a pretty good cook, and I would say that I play a great chef on YouTube.
So what's most likely to happen? I mean, if I don't know what they're gonna do with your case this afternoon, at your next hearing, your public defender could ask to lower your bond in that case. If that gets lowered, then you have an easier bond to post here. That's all. Okay.
Yeah, I'm confused. Honestly, I ain't even gonna lie to you. I'm really confused as fuck. I'm really confused.
Well, you got arraigned over the weekend on the CCW charge, right?
Okay.
The magistrate you saw then ordered a $50,000 bond.
Okay.
That's separate from this case.
Okay.
You're going to be seeing on that on June 8th, it sounds like. At that hearing, your bond could be lowered or changed, you know. So if that happens, you only have a $5,000 bond in this case. So if you're not going to post the 50 before June 8th, wait, see what happens June 8th. If you have a lower bond then you have a lower bond here already. You know, you may possibly post both of them at that point in time.
Right. So is this 50,000 10%? I mean, is this 5,000 10%, or is just 5,000 cash?
Or bail bondsman. So you can use a bail bondsman to post it.
So cash and a surety for this one?
Yep, you got it.
So and then is my other one cash and a surety too?
I assume so, but I don't have that information. Ms. Pirney just indicated it's 50,000 cash or surety. I'm sure that it has to be that way.
Okay.
All right. That cleared up for you?
Yeah.
All right, Mr. Scott. You're all set then. Have a good day.
Oh no. Can I talk to my lawyer right quick?
Well, they'll be in touch with you before your next court date for sure. We got to move on to a bunch of other cases here, but they'll be in touch with you.
And then it's the 12th?
12th of June, yeah.
You'll be talking to someone today before your hearing today, Mr. Scott.
Morning, sir.
Good morning.
Your name, please?
DeAndre Woodhouse.
Be with you in just a moment, okay?
Okay.
I'm not easy to offend, and I encourage everyone to be themselves. But I also encourage you to block anybody you don't like to see, including that Streamlabs guy. If you are bothered seeing everybody throwing around points and gambling away, feel free to go ahead and block that guy. You can be done with him, and nothing bad happens, I promise. Also, I really want to make a s'more, but I think I gotta change the propane in the fire. You just click on the person's name or the ellipses beside, and you
All
should.
right, Mr. Woodhouse, let's see what we have here.
Yes, but take heed of Raven's story. She blocked Streamlabs one night in a fit of glory, thinking she could maintain the no gambling game. But alas, she wanted him back, but could not find the
All right, this is a
unblocked.
new arraignment. This is case 23S00340, People of the State of Michigan versus DeAndre Woodhouse, alleging that on March 12, 2022, Ypsilanti Township, Washington County, State of Michigan, that you did possess more than twice the amount of marijuana allowed by MCL 3327955, identified as 84.62 grams. And the violation has a habitual or willful or commercial purpose, a misdemeanor carrying a maximum penalty of convicted of up to 90 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Yes, sir.
All right. Were you able to review an advice of rights form this morning?
Yes.
Any question with regard to your rights? Court entered a not guilty plea. The public defender will address bond for you.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Woodhouse. We are requesting just a low cash bond in this case. Mr. Woodhouse is set to be in custody until March of 2024, serving a sentence on a CCW. So we just like for him to get some credit.
Thank you.
One day I might have to turn on slow chat. That'd be crazy.
Let me get the right page here. Hang on a second.
I'm going to give you guys a sneak peek of something that's coming up that I'm working on. And I just want to see the reactions when I show you the thumbnail that I made.
All right. Conditional bond, just in case this case continues beyond your incarceration date, we're gonna set bond conditions for public safety. You're not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
Yes,
Okay, is that valid right now?
yes,
Is it still gonna be valid when you get out of jail? Do you know?
yes,
Okay. Or allow the use of medical marijuana for its medicinal purposes only, obviously after you're out of jail. It can't be used recreationally, and has to be used for the prescribed purposes. Okay.
yes.
All righty. Those conditions will be placed in the law enforcement information network. So again, this is only applicable if this case is continuing on beyond your incarceration period. But I want to get these on the record here today. Okay. All righty. Meaning if you come into contact with police, they'll have access to that information. Should they witness or suspect a bond violation, they would arrest you for violating your bond. We'll set a pretrial hearing for July 6th at 9 a.m. via Zoom and set a 2,500 10% bond to assure your appearance at that court date. All right. Okay, Mr. Woodhouse, you're all set. Have a good day.
Thank you.
Mr. Attorney, what was Mr. Woodhouse's expected out date?
March
Oh,
4th,
hold on.
2024. Or no, I'm sorry, March 22nd, 2024.
Thank you. Good morning. Your name, please?
I will.
Hill?
It'll take me a minute. Sorry.
Right. All right. Hill Estate of Michigan versus Ira Hill, 21S00365. Looks like you are scheduled to be in court November 17th of 2022. You failed to appear. Matter was set for a subsequent show cause hearing for December 22nd. You still failed to appear with a balance owing and a bench warrant issued for your arrest. Do you understand that?
Yes, sir.
All right. Ms. Kearney, you want to respond?
Yes, good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hill. From the way I read the Register of Actions, it seems like there's just fines and costs left on this case. It's already been disposed of. During that time, Mr. Hill was unable to get a job and pay off those fines and costs. However, he recently did obtain a new job at Tormino Pizza. He will be starting this Thursday. He is going to be able to make payments once he starts that job this week. He is a resident of Ypsilanti, where he lives with his fiance. He has 3 children, and he was arrested while he was walking down the streets. And the police came and ran his name and found he had a warrant.
All right. Any other warrants or anything else going on we need to know about?
Nothing else going on today.
All right. We'll go to July 6th at 9 a.m. via Zoom. Mr. Hill, you're released on a personal recognizance bond. If you're able to make any payments, of course, between now and then, that's going to help you when you come back. Okay.
Yes, sir.
All right. Have a good day, Mr. Hill.
Okay, thank you.
Thank you.
Mr. Lopez?
Hello, Your Honor.
Good morning. Your name, please.
Brandon Lopez.
Thank you. People of the state of Michigan versus Brandon Lopez, 21S00755. The request for violation of probation, failed to complete community service, failed to follow recommendations of treatment, and failed to complete mental health assessment. Also failed to report to probation for a period of longer than 90 days. Do you understand those allegations?
Yes, I do.
Okay. Ms. Perry, you address bond.
Yes, good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Lopez. When I asked Mr. Lopez about what was going on at this time, he told me that during that time he lost his vehicle, and because of his inability to get to his job, as well as having, I think he was dropping drug testing 3 times a week at that time, he lost his job as well. That kind of put him into a unstable situation. But since then, he definitely has gotten things back on track. He is a single father. His daughter is 9 years old. He has sole custody of her. He got his own place and is now staying in Belleville. He is taking community classes taking classes at Wayne Community College to become an LPN, and at the same time his roof is working as a roofer for a company called Hometown Home Improvement. So he is attempting to do what he needs to do. We are asking for a personal bond. He did say he would be willing to be on the tether if the court found that necessary, to make sure that there was a higher level of supervision because of his, inability to complete probation. But he is eager to complete it now.
Any other charges or any other arraignments going on? Anything we need to know about that?
Let me double check. I don't believe so, but I don't want to mislead the court.
He is
Coming
dressed out as
soon.
in felony color.
I had work clothes on, Your Honor. I had been on a roof for 12 hours when I had got arrested. I didn't mean to interrupt. I had shingled up. I was like black. So I asked for a new shirt.
Okay.
Yeah, XJL doesn't have him scheduled for anything else, just this.
Okay, thank you. They just gave you the wrong color shirt, that's all.
Yeah, the work clothes were filthy.
No, you're fine, you're fine. All righty. Let me I'm gonna get a few dates here put together for you of things that we need you to do, okay? So let's see, today is.
Even better.
Even if I can do weekends in jail.
Well, that's further down the road, okay? We're talking about things you need to take care of right up front here to make sure you don't get to that point.
Yes, Your Honor.
What I'm going to be doing is I will be inserting my square into a classic court case, plus the workout that I am going to be doing into the classic court case. So the 2 squares will be me trying to do the workout, and then the rest of the court. There won't be any audio of the workout, just the visual of me attempting to do the workout while you watch what the real people are doing and listen to court. Gotta do what nobody else is doing. And I swear to God, if somebody else does this before I manage to get my ass in gear.
Okay. So as I said, I was getting some dates put together for you. So it's a few things you're gonna need to do. First of all, within 24 hours of release from the jail, you need to go up to drug test up to community corrections. You know where community corrections is?
Across the street.
You got it. Yep. Remember, you need $12 in a photo ID to drug test. Okay.
I have that. I have that.
Okay. So that's before they close tomorrow. That's step one. Step two, you need to contact probation before they close on Friday. So that's going to be on June the 2nd. You have until June 2nd to contact probation. Okay.
Yes, sir.
Okay. And then thirdly, your next court date will be on June the 15th at 9 a.m. That'll be an in-person hearing. So you need to be here at the courthouse for that hearing. Okay.
Yes, sir. Thank you. Your
We'll set a $5,000 personal recognizance bond. That means you're free to go today. But if you fail to appear for drug testing, don't contact probation or don't show up for court, your bond's going to start at $5,000 at that point. You understand that?
Yes, sir.
Okay. All right. You're all set, Mr. Lopez. Just make sure you get everything back on track here. Okay.
God bless you. Thank you so much, Your Honor.
Oh, would you look at that? That's the end of it. I only work out when other people are watching. I don't know why. Seriously though, honestly, what it is I do the fitness marshal workout sometimes, and I swear to God, I look like the biggest idiot in the world when I'm doing them, and I think it would be hilarious if you had me and then what it should be. Listen, Karen, guys, Karen, formerly known as Karen, um, has informed me she likes to be called Karen. And also, Karen sounds weird to say. Like I'm forcing it out. Um, Yoga is a pyramid scheme. I don't know if you've been here when I've explained this before, but yoga is an MLM pyramid scheme to the nth degree. Okay. And I'm from, again, Vancouver Island, yoga capital of the world, pretty much. Everybody here is a yoga teacher or going to be a yoga teacher, and they're all recruiting people to become their yoga students so that they can teach them, so that they can learn how to do yoga. And one of my favorite things to do is explain that I've never done yoga ever before. And people are like, what? If I'm on a big trampoline, maybe. I have a beautiful deck outside that I'm going to be doing outdoors. It'll be an outdoor workout. I think I'm going to start tomorrow. We'll see. Laughing yoga. You know, I'm not against laughing. I will be bouncing all about, but mostly I'll probably look silly. But anyways, and the other thing is, honestly, I'm gonna adapt it partly to chairs, so people in chairs or seated can still do some of the moves. And I think it's good for us to try and get some exercise. And for me, oh, honestly, when people start to, here's the thing, there's a progression in my town of how it works for yoga. So first you start yoga and you fall in love. You're like, oh my God, yoga's amazing. I feel so good when I come back from yoga. And everyone's like, yeah, great. And then you start carrying around your yoga mat with you. You sign up for more classes. Perhaps you increase the length or you go into some sort of Bikram or other type of yoga that's more serious. Then you start either like back in the day before COVID, it would be like planning a trip to India to go to an ashram. And I'm going to find myself at the ashram and really get in touch with my being. And likely come back with a new name from the ashram where they have nothing to do with their real name. They've given it to themselves, and they want you to call them by their new name. Also, at this point, they're likely to start teaching yoga as well, and they will probably try and recruit you. Again, probably try and recruit you. And the like, I know it sounds silly, but it is seriously a pyramid scheme. It is a total pyramid scheme. And I am not against people doing workouts in chairs or relaxing or all that kind of stuff. It's the like, ugh, I think it's the like brainwashing that I think is required. Also, kombucha. Bleh. I don't want any kombucha. I'm sorry. I only stopped drinking Coca-Cola like last year. Up until last year, I drank Coca-Cola exclusively. You know, I gained weight after stopping drinking Coca-Cola. It doesn't make any sense. I literally know people that have gone to India, come back with different names. But you know what? Those same people, when they were in India, they never left. Oh, my last name. Oh, there's a Whole Foods here now, but I don't go to it. Um, yeah, I'm basically like, when I tell people in my town that I've never done yoga, they're sort of like, and then they want me to do yoga, and I won't do it. I refuse. I'll do yoga for you guys though, online, if I'm at the top of the pyramid scheme. Also, knee rack is you know what that is? That's a reverse Karen, a knee rack. Anyways, okay, guys, I love you all very much. It's been over 2 hours. I can't believe how quick the time has gone. I love you all so much. Seriously, you make me laugh so much. Kitra. Oh, Kitra. Oh, goodness gracious. You guys are crazy. If you want to know what I would go watch tonight if I needed to relax, it would be Post 10. Watch him take out some beaver dams. Some good stuff, guys. Listen, I love you very much. I will be back with some new stuff tomorrow. I hope you take care of yourselves. I'm proud of you. And I will talk to you later. Please like and subscribe. Oh, and Jackie wants to be called Jackie. Pronounced Jackie. Okay. Night, Dawn. I love you. Bye, guys. Coming soon to a kitchen near you. Kitchen Court Cardio. Working out to classic court, including such favorites as abuser gets caught in same house as victim, and Judge Washington yells at defendant. Coming soon.